This meeting is being recorded and/or transcribed.
I want to welcome everybody to the Tennessee State Board of Accountancy meeting. My name is Andy Bonner. I'm the chairman. Today is Tuesday, October 25th, 2022, and I'd like to call to order this meeting of the Tennessee State Board of Accountancy. This is the regularly scheduled meeting. It's taking place in room 1A of the Davy Crockett Tower at 500 James Robinson Parkway in Nashville, Tennessee. The meeting date, time, and locations have been properly noticed, and copies of the agenda were posted to the Board of Accountancy website on October 17th, 2022. At this point, I'd like to ask Karen to do a roll call to confirm a quorum in the room.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pam Church. David Crenshaw.
Aye.
Larry Elmore.
Aye.
Greg Gilbert.
Aye.
John Griesbeck.
Aye.
Kevin Monroe.
Aye.
Gay Moon. Aye. Rob Vance.
Aye.
All right, welcome everybody. As a reminder, all the board members here present in the room have a microphone. If you're not using your microphone, be sure and push the mute button. However, if you are using your microphone, be sure and bend it down and get it so we can record your voice for the meetings. It's much appreciated. Also, just to remind everybody in the room also that if you could put your phones on silence, that would be appreciated. We're going to welcome our visitors today and our members of the public. I know that we have Mr. Bickmore with his attorney, Roland Leathers, in the audience. And I also know that Mr. Culpepper is present here today, too. We want to welcome them. At this point, we'll go through our first agenda item, which is review and adoption of the agenda. Has everybody had a chance to look at the agenda for today? All right. Do I have a motion to accept the agenda? Do I have a second?
Second.
Karen, would you do a roll call for us?
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore. Greg Gilbert.
Aye.
John Griesbeck.
Aye.
Kevin Monroe. Gay Moon. Aye. Rob Vance.
Aye.
Now we have the minutes from the July 26th meeting. Mr. Secretary, have you had a chance to review those and have all the other members of the board have a chance to review?
Sir, and those should be on the iPads or in your packages.
All right. Do I have a motion to approve those minutes? Are there any changes at this point that anybody's noticed?
Mr. Chairman, I did receive one change on the third page when we talk about the granting of an 18-month extension to those that have exam credit on January 1st of 24. That January 1st of 24 was an incorrect date. It was listed as the wrong date. I don't know what it was, but I corrected it to the correct date.
All right. Is that the only correction that we have?
Yes.
All right. Do I have a motion to approve the minutes?
So move.
Do I have a second?
Second.
Karen, if you'll just call.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore. Greg Gilbert.
Aye.
John Griesbeck.
Aye.
Kevin Monroe. Gay Moon.
Aye.
Rob Vance.
Aye.
All right.
Mr. Chairman.
Yes, sir.
Wendy, would you repeat, where was the change? Page 3, did you say?
Yes. Well, page 3 of what I've got printed out here. It was at the it's after CPA evolution it's part of the CPA evolution when we talk about the transition recommendation, and it's the motion at the end of that, where we say a motion and second to grant an 18-month extension to June 30 of 2025. For those candidates having credit on an exam section on January 1st of 2024. I believe that was listed as January 20-something. What was
24th.
it? 24th.
Okay.
So we just corrected the date.
Good, thank you.
All right. Executive Director Wendy Garvin, and I think you're up next with the Executive Director's report.
Right. Thank you, Mr. Chairman. Good morning, everyone. The Executive Director's report is on the iPads and was also distributed before the meeting for y'all to look at. The first section is future meeting dates. The first 4 there have already been approved, and then I am proposing the date for January of 2024 as Tuesday, January 30th. And of course, the committee meetings will occur on the day prior. So we can vote on that at the end of the report. As far as NASBA meetings go, we have the NASBA's annual meeting coming up early next week. Starts Sunday evening and goes through Wednesday. That's in San Diego. Andy, Larry, Greg, Kevin, John, and I plan to attend that meeting. So we are looking forward to the information we'll learn while we are there. Related to the CPA exam, you will see attached this report, the examination performance for the second quarter of 2022 for Tennessee, as well as overall statistics across the country. Mutual recognition agreement with Hong Kong. So the IQAB committee establishes MRAs with professional accounting organizations, and our MRA with Hong Kong is going to be expiring on 12/31/22, and it is not going to be renewed. So there has been a process in place where deadlines have been established for anybody interested in obtaining international reciprocity through that agreement. Will need to apply by a specific date and those types of things so we can get them in before that expires. So in summary, the Hong Kong Institute of CPA Council resolved that the audit experience obtained in the U.S. will not be recognized towards meeting the audit experience requirement for obtaining the practice certificate in Hong Kong. So there's some differences there between the organizations. Board office location, we moved our offices last week from the 9th floor to the 10th floor. So as I mentioned yesterday, we've kind of compacted our space a little bit more, so we should be saving some on rent going forward sometime in the next fiscal year. Communications, we did distribute some emails in October leading up to renewals at the end of the year. One was reminding people of their state-specific ethics requirement, because that's the biggest item we see in the CPE audit deficiency is folks just not getting the correct course. So we reminded folks of that, gave them a link to where they can find an acceptable course. And then we also did an email encouraging people to review their CPE, and if they might be considering changing status, to go ahead and do that. It'll help with the renewal process as we get to the end of the year. Renewals will go live on November 2nd, and we do plan to do postcard reminders for the second consecutive year. Outreach over since our last meeting, I did attend the TSCPA Appalachian chapter meeting with the leadership of TSCPA and gave a 15-minute board update. So it was a gracious group. I enjoyed going to that side of the state. That's the only time I really get to do that. So October 5th, I did a CPA 101 event along with NASBA, and TSCPA sponsored it. And it was a chance for myself as well as NASBA to explain to candidates or to students the requirements of becoming a CPA and how to go through that process. And we were there to answer questions. It was about an hour and 15-minute presentation, and we had a lot of great questions. So I'm hopeful that maybe we get more participation, but when the participants we do get ask a lot of great questions, so it's encouraging. The CPE audit. So we are nearing the end of the CPE audit for this current year. Notices were mailed out in May, and the deadline to respond was August 1st. We did have 100% response, and that is very much thanks to Leanne on our staff and Karen, but Leanne makes extra effort towards the end of the period to call people, email people, and just really encourage them to respond and help them if they have questions or concerns about how to do that. So you'll see there in the chart kind of the statistics on where we stand. We have only 5 remaining folks that were found to be non-compliant and are still waiting to submit their penalty hours. If they do not submit the penalty hours in time within the deadline, then we would open a complaint. So, but as hopefully those folks will turn their information in and we won't have any complaints related to continuing education. Now, one of the items to note is that out of the entire population of 578 licensees, 580, we have compliant with penalties submitted. So there were 38 that were found to be non-compliant and submitted their penalty hours. And then we have the 5 remaining. And so when we talk about compliance rate, hopefully we end up having 100% compliance. Everybody submits their penalty hours. But it is important to note that we had, it looks like about 43 that ended up with penalty hours after the assessment. And so that compliance rate brings us to about 93% with those folks having to submit penalty hours. For comparison's sake, most states do not give folks an opportunity to make up their deficiency through penalty hours. And so in some other states, we would automatically open a complaint on those 43 people. So when you hear other states, especially when we go to NASBA meetings and you hear other states talk about their continuing education or their CPE audit, those states would have opened 43 complaints and gone through that process there. So just items to note. Performance metrics, these are internal metrics that we focus on in support of the governor's initiatives, and we look at average number of days to license, and you will see that's ranged anywhere from 9 to 12, 13 days over the past 3 months. Case and complaint performance, this is how many complaints that we are able to resolve in 180 days. We are at 98%. And then an online adoption rate, that's how many folks are applying for licenses online versus sending paper in. So we have good results there. And at the end of the report is your typical licensing statistics for the previous 3 years as well as the current year. How many new licenses we've issued. So far this year, we've issued 463 licenses and 45 permits. I have that added section of how many new candidates we are seeing with the CPA exam. And so far through Q2, so halfway through the year, we have 254 new candidates entering the pipeline for the CPA exam. And then, of course, the final chart there is our overall licensing numbers. So at the end of September 2022, we had 12,014 active licensees and 4,395 inactive licensees. And there are various other categories you see there. And then we had 1,826 active firm permits.
Any questions for Wendy?
I have a question. You've heard this from me before, but am I correct that we still do not receive the percentage of students who pass all 4 parts on the first sitting?
We do not. I can request a list of those on whenever from NASBA, but it's not something we regularly see a report on.
I personally see this as a very important metric, particularly as we change the CPA exam, which is the entrance to our profession. For other professions, that's the rate that you hear is, well, the pass rate is whatever. And if you search online, you find, well, the pass rate's about 50%. It's not. Each section is 50%. And you've heard me bring this up before. But I think we should request the ASCPA to release those statistics on a regular basis, because that needs to be public information, I think. And I think we need to monitor the change, if any, from the old exam to the new format of the exam, so that we know what's happening to this gateway to our profession.
So are you familiar with the pass rate of all 4 parts on the first chart? It's pretty low. Okay.
I've heard between 10 and 20, so I'm not the expert. I know you and I asked Mike Decker one time, but I don't know why it's not available. That to me seems so logical. And as a professor, that's what students want to know. What's my chance of passing all 4 parts? Because in a profession where all the parts are taken at the same time, of course, that's the rate that you get. I hope we're not hiding it. I think it needs to be public information.
I'll look into that a little more.
Right, thank you. We did have one. Well, let me stop right there and just say, are there any more questions for our Executive Director, Wendy? Seeing none, we did have one action item there that we needed to vote on. That's for a future meeting in our first meeting in 2024, and that date has been proposed as January 30th, 2024. Do I have a motion?
So moved.
Do I have a second?
Second.
Karen?
Wendy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
David Crenshaw,
Aye.
Larry Elmore,
Aye.
Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Kevin Monroe,
Aye.
Gay Moon,
Aye.
Rob Vance,
Aye. Today we have a reinstatement application appearance. That would be Mr. James Bickmore. His attorney's here. I'll ask Stetta if you would go ahead and present that, and then we'll ask Mr. Rollins if he would like to come up and make any comments and then introduce his client.
Mr. Chairman, I need to recuse myself from this discussion. Thank you.
Pardon me for not saying that right up front. I apologize.
Thank you, Mr. Chairman. I would just start with some background and some factual history, and then I would like to touch on the law a little bit as far as what the board's discretion is on this matter. To start off, Mr. Bickmore is seeking reinstatement of his individual CPA license. His license is currently in suspended status, and he submitted his reinstatement application on June 1st, 2022. And on July 26th, which was our last meeting, his application was evaluated by the board for completeness. It was approved for presentation at today's meeting. As far as the factual basis of Mr. Bickmore's suspended status, in December of 2020, Mr. Bickmore entered into a consent order with this board based on a complaint alleging that he failed to report to the Department of Revenue the sale price of an airplane that he purchased in 2016. After a request for information, Mr. Bickmore submitted an affidavit stating the purchase price of the plane was $18,500. However, the Department of Revenue later discovered that the purchase price of the plane was actually $128,500. Subsequently, Mr. Bickmore reported a correct price and paid the accurate tax amount, along with the interest that was incurred on that. And consequently, the board disciplined Mr. Bickmore pursuant to Board Rule 0020-04-032B, which was related to fiscal dishonesty, as well as Board Rule 0020-04-032E, which was related to willfully failing to file a report as required by law. It was in December of 2020 that Mr. Bickmore agreed to voluntarily suspend his individual CPA license through December of 2021. In addition, he had agreed to pay a civil penalty of $2,000 and completed a 3-part NASBA ethics course. Mr. Bickmore has complied with all of the terms of the consent order, and now he's applying for his reinstatement. And as far as the board's discretion, here in my memo, I note that the board's discretion can be found in Board Rule 0020-01-10, that the board really has a wide discretion when it comes to these matters. The board may consider all activities of the applicant when reviewing applications for reinstatement. The rule allows the board to consider the offense for which the applicant was disciplined, the applicant's activities during the time that they were in good standing, their efforts when it comes to their rehabilitation after the discipline, their restitution or damages paid, their general reputation, and also the board is free to ask any questions to the applicant, not only to them, but also to any injured parties in the matter. And so with that, considering the fact that Mr. Bickmore's original application has met all the requirements for completeness, now I understand he's in the audience, and if the board has any questions for me as far as your discretion, I'll be happy to answer those. And as we go along, if anything comes up as well.
Okay, thank you. I think at this time we'll just we'll ask the Honorable Roland Leathers to join us at the mic and just give us a summary of his thoughts and then introduce his client. At that point, I think that we are open for asking any questions that we might have with Mr. Bickmore. And also, if you have any questions for Mr. Rowland, please speak up. Mr. Rowland.
Chairman Bonner, members of the board, I appreciate that introduction about the Honorable Roland Leathers. Not only am I a lawyer representing Mr. Bickmore, but I'm a licensee regulated by the members of this board, so I am mindful of that obligation and that responsibility. Mr. Bickmore has been seemingly at this process for years at this point. He made a mistake several years ago in connection with his reporting of use tax on the purchase of an airplane that he bought many years ago. He entered into a plea agreement on the criminal side. He accepted responsibility there. He owned up. That criminal conviction has now been expunged. He entered into a consent decree with this board whereby his license was voluntarily placed on suspended status. He was requested to engage in certain activities by this board in order to prove potentially his worth or his merit to receive reinstatement of his suspended license. He has now done that. He has filed the appropriate documents to be back in front of this board to ask you all to respectfully consider his application for reinstatement. He also is a licensee in the state of Texas, and he now has achieved reinstatement of his license there. So what I would like I'm going to ask Mr. Bickmore to come to the stand and explain to you all exactly why it is he wants this license back. Mr. Bickmore, even though younger than me, is still probably late in the third quarter of his professional career, maybe early in the fourth. And, he very much wants this license back. It's a big deal to him. He worked very, very hard to get it. And he would like to end his career for how many ever years left with an active CPA license regulated by this board. Thank you.
Thank you, Mr. Leathers. Mr. Bickmore, we appreciate you coming here today and being present for this board. It's always very favorable when somebody comes before us and allows us to ask questions, and we appreciate that. Go ahead.
Well, thank you. I appreciate you inviting me here today and for considering this application. So the reason I'd like to have my license reinstated, as Mr. Leathers noted, it is something that's very important to me. I've had a career of several decades, and have always had those three letters behind my name. I haven't actually done anything to practice, that would require the CPA license. But, once you kind of get into the profession, you fulfill the requirements of the profession. It is just a really, you understand the arduous nature of obtaining a license, and it's just really instilled upon me the solemn nature of that, and I just feel it's very important, even though professionally I don't use it. It's just an important designation, one that I've worked hard for and worked hard to maintain. You know, you maybe you're like me in that you get other designations, you know, that in the professional nature of whatever work you're doing, but this one is different. This one is, you know, requires to prove your merit annually, and it requires you to maintain integrity. And there was a lapse there. I haven't tried to excuse myself with that. It was just a really, really dumb thing to do. And I just you know, come to you to ask for my license back, even though based upon, you know, my own actions, I know that it was rightfully revoked. Thank you.
Any questions for Mr. Bickmore?
Mr. Chairman, Mr. Bickmore, thank you for being with us today and talking with us about this reinstatement possibility. I wanted to ask you on the petition for reinstatement, one of the items noted that I believe I understand that you currently do is compliance reporting. Can you talk with us about that?
I'm sorry, could you repeat the question?
On the petition for reinstatement,
yes.
It says, as a consultant, his work generally involved finance and accounting consulting, budgeting, compliance reporting. And so I'm specifically asking about the compliance reporting. Could you talk with us about that?
Sure. I've since moved on from my consulting practice, but I believe that was referring to things like taxation consulting, the compliance there. I was involved in some the DFAR. Regulations.
So to clarify, that was prior to your license being suspended?
Yes.
Correct. Okay. Thank you.
Yes.
Mr. Elmore?
You know, I had a question.
You went to the mic.
Just assumed it, right? I have a couple of questions for our legal staff first. Does the fact that his record was expunged limit what we can ask?
The way the Tennessee law is written on expungement, it reverts this person's status back as if they never had a criminal record. And so in this case, even though I really appreciate Mr. Bickmore's attorney mentioning that part of Mr. Bickmore's story, I think it would be best if we refrain from discussing that part, because I believe that Mr. Bickmore has the right to not have that be part of the conversation the way that Tennessee law allows him to. So as it stands right now, Mr. Bickmore does not have a criminal record. That's been expunged. That's not part of his story anymore. So I would suggest that the board refrain from discussion of the criminal charges.
So does that mean we can't ask him things like, how'd you get into this mess, or why did you do what you did, or?
Well, so the facts that the underlying facts that led to the criminal charge are believed the same as the facts of the consent order for which this board disciplined him. And so we can talk about those facts are the same. We can talk about them in the context of the consent order and what the board disciplined him for, but not in light of the criminal charges. I hope that makes sense.
One more question for you. The document here says that one of the things he violated was failing to file a report. But am I confused? I thought he filed the report. He just filed it wrong.
Well, I think the board rule that I was referring to is relating to willfully failing to file a report or a record. That was what the board disciplined. That was one of the rules that the board used back in 2020. And so I put that in there because that's what was put on the consent order. I believe the previous council's logic here was, even though the report was filed, it was not done properly. And so as if there was not really a report filed. I believe, but I cannot really speak to what was intended back then.
Now, turn my attention to you. I as well appreciate you coming. Excuse my voice, I'm recovering from throat cancer, so I can talk, I just don't talk well. One of the things that our responsibility is as board members is to not only regulate the profession, but protect the public from people practicing or having licenses and not following the rules. So we take that very seriously. So one of the things I'd like to hear you say or hear you talk about is, how can we be assured that this is not something that's going to happen again? What have you learned from this experience? And this is crossing the line on what I shouldn't ask, but I hear you talk about how seriously and how much importance you put on having this license. So if you felt that way before, why did you allow yourself to get into this situation? So if I've crossed the line, tell me.
Don't worry, I'll let you know.
Okay, thank you. A lot of good questions there. You know, what got me into this was just really, I've asserted it from the beginning, and this was just a really stupid mistake. It was a lapse of judgment. You know, I really regretted that, obviously, from the onset. That's not a satisfying answer, but that's really what it amounts to. There was no other motivation. I mean, I've gone over this a lot. I'm not the type of person that's even particularly motivated by money. You know, I do things that are of interest to me, and that's, you know, way far down on the list. And so to act and do something, you know, that was dishonest, that lacked integrity over the issue of money is really distasteful to me. And I've been, you know, really, I feel like I've been hard on myself as well. All I can say is that I've this experience, and as Mr. Leathers noted, it's a process that's happened over many years. I get reminded of this regularly through communications and through other people, you know, looking at this and asking me these questions. I can just say that I really am 100% behind living a life of integrity, because at the end of the day, that's really the only thing that you can really bring to a relationship after your competency and your professional judgment and things like that. It's all of those can go away, you know, if there's a lapse or a lack of integrity. And so this this process has helped me, understand that, like, to a degree that I have never understood it before.
So if you wouldn't.
So when you say it happened over a period of many years, you're talking about the process of getting through all this.
Yes. Yeah.
Yeah.
Mr. Moore's had to deal with this issue in connection with client discussions and also recently in connection with a business he acquired and he's now operating. It might be helpful for you to explain to the board exactly how you dealt with that within that context.
Sure.
We'll explain how it's been addressed subsequently.
Yeah. So, sorry, I didn't want to be so oblique, but yeah. So I recently, a little over a year ago, basically purchased an engineering firm, and we're involved in it's sort of a technical bend, but one of the things we're involved with is the Defense Department, and so as an owner of the company, I needed to get a security clearance, and so we had a really long talk about that. You make application and then they interview you, and of course this came up because although my record was expunged, that people like the Defense Department and the FBI, they can see all that stuff. It goes to part of your background. It comes up in conversations periodically because the Department of Revenue, they have a website on who did what, and my name is mentioned there. Again, the expungement doesn't go to that either, and so occasionally people, business associates, family, have asked me about that, and so it requires me to go over with them, what happened, the questions that you're asking, they want to know as well. Was this really a lapse in judgment, or does this go to your nature, your character? And so we have to talk about that, and I've had many conversations about that. I have lots of opportunities to talk about it, and so I have a lot of opportunities to revisit this situation, not only professionally but in my personal life, and all I can say is that every discussion I have just makes me more committed to show that I'm a person of integrity. I did make a mistake. That's hypocrisy, and determined not to let that happen again.
What you said there at the last was what I was hoping to hear, is that you do realize you made the mistake, that you're committed to not do it again, and that you've learned from the experience. Because like I said, we take our fiduciary role of protecting the profession and the public very seriously. So I think you, as a member of this profession, most likely appreciates the fact that we do take it very seriously. So thank you for your answers.
Any further questions?
Chairman, I had a question or two, follow up here for Mr. Bickmore. In your reinstatement application, and narrowing in on the situation where you mentioned you had acquired a small business that does operate, at least to some degree, in the defense industry, and you had to go through a security clearance application process. Your reinstatement application indicates that you were, in fact, granted a secret level of clearance. My question is, were higher level clearances such as top secret or SCI types of clearances sought and not granted in this process?
No, that was the level that we sought, and that was the level that was granted. The other one is, I mean, it doesn't. They don't add any other benefit to a person in my position or a company in our position, and the things that you have to do to get those are really intrusive.
I understand. Yeah. Thank you.
Any further questions? All right, thank you, Mr. Bickmore. I'll let you sit down. At this moment, we have Mr. Bickmore has presented himself with his attorney and has asked for reinstatement as a CPA in the state of Tennessee. Do I have any motions?
That we grant statement of his.
Second that motion.
All right, I have a first and a second. Any discussion?
I think the one comment I would have, and I think we mentioned this at the prior meeting, with respect to being a CPA and committing violations that might be termed as, fraudulent tax-related activity. I mean, that gets to the heart of the profession. And so I'm appreciative of the fact that you've come here and taken responsibility for that situation. And if reinstatement is granted, I'm very hopeful that nothing like this at all will ever rise up here, and that can be in the rearview mirror rather than looking ahead at the hood of the car here.
Further discussion? And just to make a note again that Ms. Moon has recused herself from this vote, and I'd ask Karen to do the roll call.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore.
Aye.
Greg Gilbert.
Aye.
John Griesbeck.
Aye.
Kevin Monroe.
Aye.
Rob Vance.
Aye.
Mr. Bickmore, you're now a CPA again. So thank you for coming. We're counting on your integrity and your professionalism as you go forward. This board, you present yourself today in front of this board to be that person, and we hope that we don't see you in the future. And so, thank you. Skipped one part in looking at the agenda, and I'm going to come back to it, and that's committee assignments. Whenever we start a new year, we always have our committees on the day before. This is our committee assignments for 22-23, and so the chair appoints committee members to be present and to serve on the first day, with the board then ratifying and making that official. And today I say that we have all gotten the committee assignments in advance, and I would like to seek a motion to approve those committee assignments.
So moved.
In a second?
Second.
All right. Karen, if you'll do the roll call for us.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore. Greg Gilbert.
Aye.
John Griesbeck.
Aye.
Kevin Monroe. Gay Moon.
Aye.
Rob Vance.
Aye.
Next on our agenda, we have a reinstatement application. As we just went through today for Mr. Bickmore, this is for review and to vote to see if we bring this forward to the next board meeting that we have next quarter. I would like to point out that Mr. Todd Culpepper is present here today, and we appreciate you coming. I think it makes a big difference when people come and are involved in this process. And so I would ask Theta to read the report here.
Thank you. Mr. Culpepper has submitted an application for reinstatement, and at this meeting, his application is being presented for review of completeness, and then if the board decides that the application is complete, then at the next meeting, Mr. Culpepper can come and present and speak to the board, and the board can evaluate his application on its merits. However, I would like to note something that was brought up to me that I inquired further into, and that really is the requirement for initial application. The statutes and the board rule as it currently stands do require the applicant, and let me just pull it up here specifically. It is board rule 0020-01-.10122, requires that an application for reinstatement shall consist of a signed and acknowledged petition, which shall set forth in full the circumstances surrounding the revocation or suspension of the applicant's license, the applicant's reasons for seeking reinstatement, and any other information that they wish to bring to the attention of the board. And here, the way that I read the rule is that we have to have an application that consists of a written petition by the applicant outlining the circumstances and what had happened, why the discipline was imposed, also the reasons why they're seeking this sort of application. And from what I understand from Ms. Garvin and the way that this initial process has been done is there's been a little more provided by the applicant generally than just the application form. In this case, Mr. Culpepper has submitted the application form that is been issued by the board along with appropriate fee, but we have not received a signed and acknowledged petition from him, and we also have not received any type of document stating the reasons for seeking the reinstatement or anything else additionally. What we've received is the application form, the fee, and then the previously executed consent order that the board issued. And then we've also received a court document relating to that consent order. And so here, the way that I read the law, the way that I believe is intended, and the way that the board has been doing this, it is my opinion that the board could find this application to be incomplete for the purposes of today's meeting, because there are some material documents, the material pieces to it that we have not received. And in my memo, I go into a little more detail as far as what a petition would be construed as, and that is a formal written request presented to a court or other official body. Here we've received no such request besides a filled out application form and then a consent order. Consent order that the board and the legal department specifically in this case had years ago written for the purpose of disciplining Mr. Culpepper. Sure, there are facts in there that go to the reason for the discipline, but I don't believe it submitting a consent or previously executed consent order rises to the level of what's required by our board rule in the form of a petition. And so with that, I believe the board, in reviewing the application for completeness, should consider these facts. If you have any questions, please let me know. I'll be happy to answer.
Any questions for Feta?
My question is, it seems like the application would say this application should be accompanied by a formal petition. Am I wrong? I don't see that it says that. But my other question is, has there been communication with him to explain this?
So the application, I don't believe it says
There's explanation of yes answer.
Right, and there is an explanation to a yes.
It seems like it should say, in addition, the person
and I see what you're saying. Unfortunately, I have no, I don't have anything to do with how the application has been written. I am going off of what the statute, what the board rule says. In this case, I'm aware that Mr. Culpepper has an attorney who has aided him and guided him through this process. In my legal opinion as an attorney, I believe it is, in this situation, probably something up to the attorney to have perhaps considered or looked into. When it was brought up to my attention, the concern was that there's other applicants that have complied with the board rule, even if it was not put in there. And so in this case, perhaps I think the concern is that the board might be setting a precedent for not really being uniform in the way that it's been done, in the practice that's already been established by this board.
Comments?
One question. I understand the kind of the form and substance, arguments that you're making with respect to this. If you just simply substantively looked at what legal counsel believes is missing from this application for reinstatement that is a necessary condition to be there for the board to affirmatively process it, is it primarily the fact that the petitioner does not state reasons for reinstatement, or is there something beyond that is missing?
I think the way that the rule is written is it puts a sort of expectation on the applicant to show an effort, and I think to show more of an effort that has been shown here. And again, I don't want to assume, but I am just looking at the way that it's been written, the way that it's been done in situations where applicants are seeking reinstatement for their license. And we saw today from Mr. Bickmore as well, just that setting forth some of that initiative. And so I think here, when it was first brought to my attention, I think that was the initial concern, is lack of effort that has been required and shown in the past by other people in similar situation. I don't want to assume that, and I don't want to put that. I think that's something for the board to decide in your discretion, which you do have. I also think the concern was setting up what kind of precedent and just really going outside the lines of what's been done already.
I have a question. I guess this question is for Wendy, but internally, and maybe this is for a discussion for another time, but internally, do we have a system whereby when an application like this is submitted, we have we got this, a checklist, so that we know before we get to this point that something's missing? I mean, it seems like there should have been and I'm not faulting anyone, I'm just saying it seems like there should have been a stopping point in the process that said, okay, we're missing some stuff here, let's call this guy.
When we receive the information, we typically just send it over to the legal staff with any additional information that we might have on file. I had communications, it looks like, with his attorney in early September, giving directions with providing the board rule and the information that we would need as part of the application. And so once it was received, we didn't go through that particular process of saying, well, there isn't a petition and going back, and we haven't had a situation like this.
So are we talking about we're missing a state form, or is it just some narrative that was supposed to have been written?
A narrative that is usually accompanies the application as noted in board rule.
So it's the narrative of why I want to have my license back?
Circumstances surrounding the suspension or revocation, why you're seeking.
The previous case, Mr. Bickmore as Savetta mentioned earlier, there's a petition for reinstatement, and I think that's basically what we're missing in this case.
Correct, correct.
I get that, but I think the form is misleading by saying if you answer yes, then you need to explain it below. It seems that like it should say then you should explain it below and include XYZ, because it probably feels like once you've done that explanation that you have explained everything, because we have the background and why it occurred. It just seems, since we meet quarterly, that a lot of time could be saved.
Let's just ask him now. I mean, I know it's not in writing, but he's here.
That's what I was just getting ready to say. Can he do it verbally?
Just give me 1 second. May I ask for a recess, a short recess? My concern here is that Mr. Culpepper has an attorney who's not present, and I just want to be mindful of that. We as attorneys have the duty to not really engage in direct communication with people that are represented by an attorney. So I would just like to take a brief recess, consult with my chief counsel, and then get back to the circle back if possible.
Before we do that, can I say today our only decision is whether to hear the case in the future. Is that correct?
Correct.
Could there be a decision toward that? We're not hearing the case today, so if a decision could be made that would facilitate some sort of vote contingent on something.
Yes, and what I was going to mention also is that I don't think that the board necessarily has to or needs to deny and say, well, submit all over again, do the whole thing again. I think the board can say either do that or say cure your incompleteness. I think perhaps the only thing there would be that there will still be a slowdown in the process where the next meeting will have to redo what we're doing now to evaluate it for completeness. I don't believe that the board necessarily has to or needs to deny. I just want to be mindful in engaging Mr. Culpepper as far as his reasons, because he's represented by an attorney and because an attorney prepared this as well. And if we, I think, would get into some of the meats of perhaps a petition or reasons, which really is meant for the meeting after this one. And so I would just like to keep things a little cleaner on this end. I hope that makes sense.
So, two questions. The first one is, just based on what you have said and what our executive director said, is that we gave the attorney the information via email that he could have corrected this before we got to this point.
Correct. About a month, almost 2 months ago, Wendy, is when you...
September 8th.
On September the 8th. And I understand, Mr. Schertz, that we didn't have a boxer to check, but it looks like the staff reached out to them and gave them ample time to respond to that.
In the board rule, which is what I...
Reached out to them before this form was prepared. So what you're saying is they got the same thing everybody else receives. Is that what you're saying?
Correct.
It would seem logical to me that we don't want to change this process to where we have in the future people coming before the meeting and say, well, I'm missing this. Well, go ahead and approve me so the next time we can get this done. That there is a method. It's stated. They get the document that it's stated, and that we've consistently done it that way.
Correct. And as I thought about this, I came to the conclusion that if we were to really, I think the duty to complete this is on the applicant.
With that being said, I will ask the board, do we need a recess, or would we like to go ahead and make a motion in this case? Why don't we take a short recess, 10 minutes, and then we'll come back and then we'll discuss it.
Yep.
Would that be okay? I'll let Karen give me a nod when we're ready. We're ready. Okay. So welcome back. We have some NASBA updates. On the NASBA Board of Directors, I'm going to let Larry kind of talk about that because it's kind of in his wheelhouse with what's going on with the UAA committee. And so, Larry.
Caught me off guard. I thought I had a lot of time to get I'm going to refer to my notes here because there's a lot of details that I'd like to cover and make sure everybody hears. But the NASBA Board of Directors approved back in October, I think October the 11th or so, releasing for a 60-day comment period this proposed revisions to the UAA rules and laws, model rules, I guess is the technical term, pertaining to the exam. And specifically, it relates to granting of CPE credit extensions, credit requirement extensions. And so the changes being proposed are that you have 18 months, a rolling 18 months, to successfully pass the remaining sections of the exam after you pass the initial part. The problem is now, the rule as it stands now, states differ as to, it varies among the jurisdictions as to how that's calculated. So in order to make it consistent for all states, this proposed rule, and it's out for comment for 60 days, by the way, seeks to provide uniformity among those jurisdictions to avoid and address future score delays, much like we had this morning, the discussion about when does the calendar start. So this proposed rule still says that the exam sections can be taken in any order. You have 18 months from the date the first passing score was released, as opposed to sit date. The initial clock starts when the first score was released by NASBA. Then beginning with that date the first passing score was released, the rolling window would conclude or stop with the sit date of the final part, because there's no need to go with the release date on the final part because that just keeps it rolling. So, and then if all sections are not passed within that 18 months, the 18 months expires. The rule also being proposed prohibits a candidate from taking a failed test section until the score is released from the previous time for the most recent attempt. So you couldn't take a section and then take it again before you found out what your score was. This rule still, it doesn't eliminate our role in this process because there's not a finality in it, because it has Let me read you this section of the new rule. Rule 5.7 provides that the period of time to pass all sections may be extended by the board upon a showing that the credit was lost by reason or circumstances beyond the candidate's control. So this is out for comment until December 12th of 22. So if individuals or if we as a board want to make a recommendation on this, that should do it by then. And I'm sure this will be discussed further at the annual meeting coming up.
Definitely will be.
One of the things, let me say one more thing. On the comment this morning on the first time passing scores, statistics, there's a lot of talk at NASBA amongst various factions on the 150-hour rule and whether we should keep it or not. Stand on that. Some discussion about that. I think NASBA's, well, I know NASBA's official position is that it should stay, it should remain. And but one thing that affects the statistics on the first-time pass rate, it used to be, and I'm showing my age now, but it used to be that the exam was given twice a year. It was given in May and November. So you took all parts, but you prepared for all parts really hard, really strong, because you knew it wouldn't come up again for 6 months. And even though you were taking the exam, like in Knoxville at the Coliseum, where there were birds flying over your head, or there was a rock concert practicing next door, you knew it was very important to study for all the parts. The thing you have now, and this is opinion, this is not official, but this is opinion, is that it's so, you can take it so frequently that I think a lot of people take it bam, 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 different sections, even though they may not be prepared for it yet. Whereas in previous years, that may not have been the case. So I think that's affecting the statistics somewhat.
Thank you, Larry. Any other committee reports?
I'll piggyback on Larry's because I'm on the CBT, the Computer-Based Testing Committee, and we had considered the language that was recommended for UAA. So I've seen all that language for several months now. And we knew that was coming. I know Gay referred to it yesterday and something about, well, the window will now start when the scores are released, and we saw the ramifications of not having that provision. So I personally support that. But we discussed that. We deal with the transition, and I was also on the transition task force. But the other item that will be upon us is BEC being phased out, no more testing after the end of 2023, and then it can count for one of the choices of a section. So the committee I don't know if you've seen this, had proposed language had proposed uniform language, if state boards want to use it, I guess, to indicate to candidates that your notice to sit lasts, how many months do our notices to sit?
Until it lasts 6 months.
6 months, except in the case of BEC, and even if that was issued sometime in late fall 2023, it ends, whatever the date is, at the end of 2023. So,
there's some very convoluted rules that are going to be in place for this transition period. And I would encourage all of you to not study up on them, but at least read them, because you're going to be getting a lot of questions from people on what if I do this and how does that work. So even though you're not considered to be a source for factual answers on those kind of questions out in the public, but at least everybody would be good to know, because there's a lot of possible scenarios that NASBA has thought about and tried to answer, but there's no way to anticipate all of them. So.
And in general, once these new parts are being given, the scoring is going to be tougher, and so score release dates, I don't know what they're doing about that, and it may just be something they're going to have to wait and see. But we also talked about government issued IDs. You may have considered this, but Prometric is considering or has approved allowing those for people who are taking tests, and in some cases it's not a hard copy, and so they're going to have to be sure, very, very clear about the rules as to how those can be used, and if they would have access to some database where they look them up. And anyway, that's an administrative thing, but that's something else we had considered.
There's some folks out there that believe, and I don't know, I'd like to hear your opinion on this, whether the upcoming changes are concerning enough students that it could be affecting our pipeline. In other words, are they so concerned about, gosh, this is a whole new process coming up? Is that making some students think, well, I'll just go into finance, or I'll just do something else?
Data analytics.
Yeah.
I think that it's interesting to look back to when I know Colin Conrad visited our meeting, and maybe a couple of others, to talk about there's a cry to make our profession, our testing, more relevant. We need to include data analytics. We need to be sure that the test reflects the current skills needed. So, we did the whole practice analysis, etc. And I guess what started that in motion was almost a plea to say, well, there was an admittedly reduced number of people sitting. And so, I think the hope was that this would increase the number sitting. But I don't think it's possible right now to separate the effects of COVID on education and enrollment. Fear about the new upcoming test and the draw of something like data analytics, where the salaries are quite nice with only an undergraduate degree. I'm pleased to say that I hear a lot of enthusiasm among students who are saying, if there are fewer people sitting for the exam, that means that I'll just be a more rare commodity. And so I think students, for the most part, are embracing combining data analytics and accounting. But as we all do, I think to a certain extent they haven't faced that reality yet. So they're going through the process, and I don't think it's really hit them. But for one thing, they didn't know the old way. So,
well, the other thing that's being discussed, I don't mean to steal your thunder on this, but the other thing that's being discussed at NASBA right now on some of the committees that I'm on is that we've got to help change the perception of our profession somewhat by, every student's got an uncle that's a CPA that talks about he works 80 hours a week. Gosh, last week I didn't go home all week. I just stayed and worked. We got to quit that. We got to start talking about the exciting, challenging parts of the profession rather than how many hours we worked. And, it's going to be hard to change.
I went to a student night at the TSCPA chapter of Memphis, and they had a panel. And that was a question, was what about work-life balance and et cetera, et cetera. And some of the things were reassuring. Of course, it's totally different than when I was out there because you can work from home. And so there were huge debates about, is that better or worse? But also someone said, well, now the most active hours for logging in and working are 8 to 11. And I thought, that doesn't sound reassuring to me. And then others said, well, we have to work, I don't know, it's 50 or 60 hours, but we can do it when we want to. And, productivity, there's so many studies that show that productivity goes up if you can have rest and removal from the situation. And I think our profession actually needs to change. Not you're right. We need to advertise the positive parts, but I hope there's also change.
I'm not saying we should just start. I'm not saying to hide how many hours you work. I'm just saying don't work those many hours. But if you do, at least shut up about it.
Can we quote you?
So I would like to add that I have talked to several firms, and they're very understanding of that and very concerned, and they are starting to enforce a 40-hour work week. So that is very encouraging. So we are starting to see some change in our profession, and so I would say that I actually learned more when I spent more time, kind of overtime, kind of drilling down into the things I didn't know, and which made me a better CPA. But I know it's a new generation, and they probably get better education than I did with the extra 30 hours. So with that, any other committee reports? All right, seeing none, we have our counsel back in the room. Veta has gone out and kind of looked at this, and we ask you for your comments, please, ma'am.
Thank you. After speaking and consulting with my one of my supervisors upstairs, and just thinking about this more, it would be best if the board keeps today's discussions as to whether what we received is complete or not, decides on that issue, and then we keep that in this order. I would like to point out that the board doesn't necessarily have to deny this application. My recommendation would be that the board considers allowing the applicant to amend it for review at the next meeting. So instead of just denying it and having him resubmit everything again, along with a fee, I think what would be appropriate here is allowing Mr. Culpepper to amend the application with what's required. I have spoken with his attorney. He is aware of the missing parts, and I think that would be appropriate in this case. And then for the next meeting in January, for us to review what was submitted for completeness, and then go from there for review at the meeting after that. So that would be my recommendation. The board is free to take it or leave it, but I think it may be appropriate in this case. And if you have any questions, please let me know.
This is Janet on the phone.
Wendy to chime in and give a perspective from the staff viewpoint, or if she has any comments, and then we'll open it up for discussion.
Thank you, Mr. Chair. I agree with where Sveta is on this. I think that we want to do our best to stay in line with what the rules say and try to be consistent how we approach.
Crenshaw?
Yes, just as the attorney member of this board, wanted to say I do appreciate our counsel in her position of not wanting to speak with someone who's represented by an attorney without his attorney present. So I think that's a very reasonable concern. That being said, I do think the rule is pretty clear on what needs to be submitted. And I would also agree with Sveta's recommendation that we look at potentially allowing an amendment as opposed to an outright denial.
Any other comments?
This is Janet on the phone. Since I think it said in the application information that this applicant's record had been expunged, so how much information can we expect to see regarding the, I guess, circumstances of the revocation and reasons for reinstatement? And I guess I'm wondering if that's why some of this information wasn't included.
That's a good
Because
question.
it's as if it never happened.
Correct, and just like with the previous case, the underlying facts for the discipline that the board imposed were the same as the criminal repercussions, I guess, and so the board is free to evaluate and discuss the facts of the consent order, which are the facts leading to the discipline, and so an expungement will not necessarily erase board action and the underlying discipline here when it comes to administratively what led to the suspension. And so the petition, just like in Mr. Bickmore's case, would go to the facts of the consent order and the facts prior, during, and after the consent order, and really is what I believe in spirit with the law, and what the board will require an applicant to showcase, okay, this is what happened, this is how I dealt with it, and this is where we are now. And so that's the part that we're missing here, with just a simply submitted and executed, a previously executed consent order, the purpose of which was discipline, and not necessarily putting out that information by the applicant. And so the board would be free to look at that, look at those facts and consider those, and certainly for them to be in the petition. So I don't believe the expungement here would limit us in that way.
Any other comments?
Mr. Chairman, in the original disciplinary proceeding, I was the board designee to participate in the informal hearing with the applicant now for reinstatement, so I think it's most appropriate that I would abstain on our reinstatement decisions. But from a process perspective, I think the comments that Dr. Church made with respect to perhaps on our form being a little bit more clear, so that the applicant or their counsel has a more explicit list to follow rather than intuiting through interpretation of the rule. I think that might be helpful to head some of this off going forward.
Thank you. So before us, our counsel has come to us to say that we consider approval of this reinstatement pending completion of the required documents, so that we would not delay this any further for Mr. Culpepper, and that it would be present at our meeting for a vote.
I think I think the board can take my recommendation, which was slightly different.
Okay.
My recommendation was to allow Mr. Culpepper to amend the current application to be presented for review of completeness at the next meeting. That way, the meeting afterwards in January is when the board would review it on its merits, the way that we did today with Mr. Bickmore. Now, the board doesn't have to take my recommendation. The board could decide to allow Mr. Culpepper to amend it, and then if that is complete at the next meeting, to evaluate it on its merits. I would just like to, it really would depend on what kind of precedent the board would like to either set or change. I think really it comes down to procedurally what you feel comfortable with, because my concern is that we treat everyone the same. And in situations like that, I think it would be cleaner in the future if we follow the process, because the more exceptions we make, the more we have to consider them for other people, and I would just hate for us to be inconsistent in that way.
Savetta, could I ask a question? Just to clarify, I want to make sure I understand what you're saying. If we do what you're recommending, we would push this decision on the application's merits until January.
Correct.
And then the vote to approve or not would be in May.
No, the vote to approve or not will be in January.
So we can do it.
well, apologize. It will be in May. Correct. You're correct. So the next meeting in January would be whether it's been completed or not, almost as if it's a redo of today. And then
be in May.
Correct.
So the chair looks for the board for comments as to what your thoughts are on this. Do we stay the course, or do we? I
think it's very unfortunate what's happened, but at the same time, I think we got to follow our rules and our precedents. I mean, personally, it's a bad situation the way it's happened, because I'm not sure. What's probably going to happen is there's a whole busy season there that you're going to miss because of this timing. And I hear that, but at the same time, I think it's important for us to, number one, follow our attorney's recommendations, and number two, follow our precedents in the past. But I do, Evan, that help future applicant checklist type.
And I have to say, I think my recommendation might be slightly different if there was no notice of what the rule actually required. Here in this case, there was ample notice as to what was actually required, and an attorney involved as well. And so I think, every situation is different, and we have to consider that into our just into the discussion of what to do. And again, it is up to you. This is just my recommendation, but it's up to the board to decide.
Can I just make sure I understand? So we're not saying to resubmit and pay another $250. We're just saying that we want to have this petition, the formal petition, added to this packet of materials, and then in January we can decide if the application is complete.
Correct.
Okay. All right.
I think it's important to, going back to what I said, it's important to remember this is not if you submit this, we're still not saying it's automatically that we're going to approve all this. It's just we got to submit that in order to move it to the next step. There's still the decision in the end as to whether the vote in May would be approve or not approve.
Correct.
So we're not given any level of assurance at this point.
Correct. Really, this is just about the completeness, the procedural process of it. That's the extent of today's discussion, and if the board goes with my recommendation, it will be the extent of next discussions too in January.
Again, requirements, because what you have in your, did I hear you correctly that the rule states that there will be an application and a petition? Because what your letter says, Section 2 states that an application for reinstatement, quote, shall consist of a signed and acknowledged petition which will set forth in full the circumstances surrounding the revocation or suspension, comma, the reasons for seeking reinstatement. That doesn't explain to me the situation we're in, because it says shall consist of a petition. Obviously it consists of a form with explanation and a petition. Am I right?
No, there is no petition in this case.
No, I know that, but the requirements.
The requirements as they are in the memo, and I have the rule. And
rule, does it state?
Yes.
Form and a petition?
It says the application shall consist of a signed and acknowledged petition. So that is different than a form.
But obviously we require a form, and that's not in the rule?
No, the actual form is not in the rule.
I think that's very misleading.
And I think the form goes more as far as I think that's an internal process that the state board does, and I think Wendy can speak to this better than I can. I am just looking at what the board rule says as far as having that the sign and acknowledge petition, that's different than the actual form.
Now also consists to a food.
I see. And
that I would think it will consist of a petition, and that I would think once I've written out my explanation, that is my petition.
But the explanation in this case did not go to the circumstances surrounding the revocation and suspension or the applicant's reasons. The explanation.
If that explanation had included that, would we be okay?
Yes.
Because what I keep hearing you say is there's supposed to be a separate petition.
Well, I think that technically the rule does indicate that it will be a separate petition. I think
it doesn't say a form. I can understand that his explanation doesn't go.
I'm reading the rule, and paragraph 1 says, who wishes to reinstate the license shall submit to the board an application for reinstatement of such license accompanied by a fee. The form is entitled Application to Reinstate Suspended License. There is a form, and it's in paragraph 1. Paragraph 2 then says, such application shall consist of a signed and acknowledged petition, which will set forth all the things. In my mind, there are two steps, two pieces.
How would the application consist of the petition? It should say there is also a petition.
Because it's an added requirement to the application. Because
they shall include, not consist of.
Well, and we can always look at amending how this is written. I think an application consisting of again, we could look at changing that in the rule.
I'm okay. I think it's very clear that it's lacking information. So I just, on my part, I would be against accepting this in its current form because it's lacking information, not a separate petition. That's just my view of it.
Any other comments? Well, we've discussed it. We brought it forth. Do I have any motions?
Mr. Chairman, I'd like to motion that we accept our council's recommendation to allow the applicant to amend, and we start this process again next quarter.
Do I have a second?
Second.
I ask for any discussion. Seeing none. Karen?
Lundy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore.
Aye.
Greg Gilbert.
Aye.
John Griesbeck. Aye. Gay Moon.
Aye.
Rob Vance.
Aye.
All right, the motion passes. So we will ask him to submit the required information. We will not charge another fee, and we'll bring it forth at our next meeting for consideration. Now we go over to board committee reports. Dr. Church, I'm going to ask you to go through the licensing part. With that, I have been informed by Mr. Monroe that he may have to recuse or abstain from voting on one of them. So we probably need to, I believe it's the Scott Taylor credit. And so we probably need to vote on that separately.
Well, let's look at the request for extensions of credit. The first one is Jude Alnajar, who passed FAR October 12th, 2020. This is an international situation. He was dealing with the Kuwait airport in the middle of COVID, and after he passed the first part in October 2020, he was unable to get to a location that offered testing until September 2021, and only then because he was willing to travel to Canada when the Kuwait airport opened. So he did so. He passed Reg and BEC, and lost FAR. And how am I? Okay, so September 2021, he passed auditing. He passed Reg April 2022, and BEC September 22nd, 2022. He's now asking us to grant an extension to September 23rd, 2022 for that part that he lost back in, that he had taken back during COVID. And the extension would be to September 23rd, 2022 to take in the date that he passed his last section of BEC. So that's 5 months and 10 days extension. And the reason is international traveling and scheduling issues directly related to COVID. So the motion in that case was to grant that extension. So we're going to vote on the extensions. Other than, which one are you recusing on?
Taylor.
Carson, Severs, Taylor.
So Paul Rigby has credit for 2 parts. He's taken auditing several times, has not yet passed, but he passed FAR March 31st, 21, lost credit September 30th, 22, and he's asking for an extension to November 25th, 2020. That's his last. Barely missed out on being able to take auditing another time, and he gives as a circumstance beyond his control the fact that the score release was delayed for, I believe it was 3 weeks past what the ASCPA had indicated as a target date. We discussed that we hope the ASCPA will clarify what they mean by target date and issue caveats when they publish that information, and be sure that CPA review companies that they deal with have the full information, because we found that to be confusing. So board November 24th. Carson Taylor. Cited a number of issues as she had tried to take the exam. She passed FAR in November 2019. It expired in May 2021. Passed Reg August 9th. Still expired. Sadly, her mother passed away July 2022, had been diagnosed.
Dr. Church, pull that mic down a little bit. I think your mic is a little weaker than most, and I apologize for that.
Sorry. Okay, do I need to start that one over?
No, you're fine. Continue
on. So her, she had really gotten sidetracked from the exam. She cited some other things, such as her son going into military service. We do not, while we certainly acknowledge that as a significant event, our reason for a motion to grant her request for an extension for Reg to August 9th, 2023 is the death of her mother and the grieving process surrounding that. So that would take her 6 months from the date that Reg will expire, February 9th, 2023 to August 9th, 2023. She knows that she has a significant way to go, but she's asking for this to give her a boost and the ability to go forward here. So I would bring those 3 for a vote by the board.
Okay, that comes to us as a motion from the committee, and so I need a second.
Second.
Any discussion? Seeing none, I would ask for.
Mr. Chairman,
Go ahead.
can you confirm, Pam, the extension for Miss Williams? Is that?
That was September. No, I'm sorry. Did I say September? August 9th, 2023.
Okay. And that is for
6 months for reg.
For reg. Okay.
That's when reg will expire February 9th. She wants to extend it to August 9th.
Any other discussion? Karen?
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore.
Aye.
Greg Gilbert.
Aye.
John Griesbeck.
Aye.
Kevin Monroe.
Aye.
Gay Moon. Rob Vance.
Aye.
All right, and we'll go back to Dr. Church for the last extension request.
Okay. This is Carson Taylor, formerly Carson Severs. She had passed auditing 2/12/21. It expired August 12th, 22. She passed BEC in June 6th, 21. Tragically, her mother passed away shortly after that. She took FAR unsuccessfully. She took REG, did not pass, but came very close with a 73. And then she passed FAR in August 9th, 2022. She's asking for an extension of her auditing part that she had taken in February 21 in order to give her a chance to pass REG. And her reason was that her mother had passed away shortly after she sat for BEC. She has the notice to sit for REG. She is prepared to do so. We noted that she was asking for, the notice to sit goes out to February, but if she goes past the end of this year, she would lose another part. So the committee's motion is to grant an extension until the end of this year, 12/31/22. That's for the auditing score.
And Dr. Church, I received an updated email from her yesterday. She has already sat for REG on October 8th. So she just was giving an update as to her.
Probably still go to.
I
hope it's not necessary.
Yeah.
Okay.
All right, that comes as a motion from the committee. And do I have a second?
I'll second.
Any discussion? I would note again that Mr. Monroe will be abstaining from any vote from this. And I'll ask Karen to call the roll.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore. Greg Gilbert.
Aye.
John Griesbeck.
Aye.
Gay Moon.
Aye.
Rob Vance.
Aye.
All right, it passed.
One more item.
Yes, ma'am.
University of Phoenix course. This is on the agenda because NASBA's CPA Examination Services team reviewed the course titled ACC 543, Managerial Accounting and Legal Aspects of Business from the University of Phoenix. And that team determined that the course should be split between 1.5 semester hours for accounting and 1.5 semester hours towards business because of the business law. The candidate is appealing this ruling to the board and believes the entire 3 should be classified as accounting. This candidate has passed the CPA exam, did not realize he was short 1.5 hours of accounting education. He meets all other educational requirements for licensure, and so he has submitted information for that course. I will say this situation can occur because it hasn't been too long we've done this, but candidates can sit before they finish their educations. When I first looked at this petition, as a professor, the first thing I looked at was, well, what's the material and specifically what are the textbooks? And indeed, there are 2 textbooks. One is a managerial accounting textbook and one is a business law textbook. But if you look more closely at the breakdown by week, in this 6-week course, 4 weeks, the first 4 weeks, are clearly managerial accounting topics. The 5th week is clearly, it's called business ethics and organization. But then the 6th week is, it looks like overlap perhaps of laws and managerial accounting, because a very significant assignment is part of that week that involves the Foreign Corrupt Practices Act. And that is very commonly covered in managerial and cost accounting textbooks and courses. So if you just take the 4 sections that are all totally managerial accounting, that's 66 2/3% of the course. The guideline generally is if it's 75%, the whole course counts as accounting. And so then if you also take that a 5th course, a 5th week involves Foreign Corrupt Practices Act, then I think that we are to the 75. So the motion from the committee is to approve this course for 3 semester hours of accounting.
All right. So our chair has presented that motion, and do I have a second?
Second.
All right. Any discussion? Seeing none, I'll ask Karen to call the roll.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore.
Aye.
Greg Gilbert.
Aye.
John Griesbeck.
Aye.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Rob Vance.
Aye.
All right. Thank you. Now we go over to Chair Monroe and ask him to bring us the enforcement report.
Mr. Chairman, just a word on process. Yesterday, the Enforcement Committee met in public session and extensively discussed and reviewed the 14 cases that we're about to review and ask for final board action with respect to recommended discipline or processing of these complaints. And so I'm not going to go into great detail given the public discussion that has already occurred, and we'll basically summarize the cases, and then would propose that we deal first with the 8 cases in the consent agenda in one item, and then we'll deal with the proposed discipline cases, and I'll highlight where the committee's discussions resulted in changes and recommendations. We have 8 cases in the consent agenda. Case 1 relates to disclosure of clients' confidential information and is recommended for close with letter of warning due to insufficient evidence to support a claim of breach of confidentiality. Case number 2 related to failure to exercise due professional care with respect to tax services. Recommendation there is to close with letter of instruction on the basis that the respondent's firm took corrective action and the complainant failed to review the return prior to filing.
I apologize,
Yes.
Mr. Monroe. Do you mind reading the case numbers into
Not
the
at all.
record as well?
Certainly. Just to go back, case 1 was case number 2022024531. Case number 2 was case number 2022021101. The next item, number 3, is case number 2022025841. That related to potential acts reflecting adversely on the profession and is recommended for closure due to lack of evidence. Case number 4, or item number 4, case number 2022023941, relates to using the term reserved to licensees in title or designation, and the recommended discipline is to close with letter of instruction with the respondent not being a licensee. Case numbers or item numbers 5 and 6 are related. Item 5 is case number 2022027481, and item number 6 is case number 2022027491. Both of these relate to a complaint that has the same allegations that are extensive, and because the complainant is facing very significant criminal charges relating to the underlying facts of the complaint, counsel is recommending closure for both of these cases it has been discussed and we considered litigation monitoring, but the nature of this may last years or decades. And so if action is taken and necessary, we can bring it back to the board at the appropriate time. So closure is recommended for items 5 and 6. Item 7, case number 2022-030591, addresses disciplinary action imposed by another state's Board of Accountancy. And the recommended outcome is closed with letter of instruction on the basis that the respondent has appropriately dealt with the disciplinary recommendations of that other board and is not currently practicing in Tennessee. Item 8, case number 2022-027141, relates to potential failure to exercise due professional care and competence. The recommendation is to close with a letter of warning, and that there was, on the basis that there was insufficient evidence to support a lack of competence and due care. So those are the 8 items on the consent agenda, and the committee's recommendation is to move forward and accept the recommendations as laid out on each of those 8 consent items.
Thank you, Mr. Chairman. So we have that as a motion. Do I have a second?
Second.
Any discussion? Seeing none, I'll ask for the roll call.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore.
Aye.
Greg Gilbert.
Aye.
John Griesbeck.
Aye.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Rob Vance.
Aye.
All right, Mr. Monroe.
Thank you. We'll now deal with the 6 cases for which there is actual proposed discipline for the board to act on. Item 9, case number 2022-021281, relates to a peer review violation, and the recommendation is a proposed $500 civil penalty for violation of the board rule relating to peer review. In lieu of the civil penalty, the respondent could provide documents in support of their medical condition or proof of closing their firm. I would go ahead and recommend that we go ahead and consider one motion to vote on all the recommendations if the board is comfortable with that, rather than doing each one. Okay. Item number 10, case number 2022-027341, relates to potential unlicensed activity and providing attest services without proper licensure. The recommendation in that particular case is to authorize a formal hearing with the authority to settle via consent order for voluntary revocation in violation of the appropriate board rules as listed. Item number 11, case number 2022-031361, relates to using the term reserved to licensees in firm name and website. Here, the revised recommendation as a result of the committee's deliberations is to authorize a formal hearing with the authority to settle via a consent order requiring the respondent to remove the term accountant or accounting from their firm name and website per the specified rule as it pertains to title or designation. Item 12, case number 2022-027311, relates to discreditable acts and fiscal dishonesty. Here, after deliberation, and in this particular case, the respondent was accused of fraudulent transactions arising from their role as the budget director for a county government. Here, the recommendation, as revised by the committee for recommended board approval, is to authorize a formal hearing with the authority to settle via a consent order for voluntary suspension of the respondent's license for 24 months from signing of the consent order, to require the respondent to appear before the board if reinstatement is pursued, and to require the completion of the 3-part NASBA ethics course. Additionally, the recommendation is to assess a $5,000 civil penalty in violation of the board rule pertaining to acts of fiscal dishonesty. That is a revision from the original recommended discipline, and that was based upon board discussion or committee discussion and deliberation yesterday in public session. Item number 13, case number 2022-031601, relates to a peer review violation, providing a test services without being enrolled in peer review. The recommended discipline there is to authorize a formal hearing with the authority to settle via consent order, assessing a $1,000 civil penalty for failure to comply with the peer review requirements as set out in board rule. Also recommending including in the proposed consent order a requirement for the respondent to complete a peer review exemption form. Item 14, case number 2022-033111, relates to failure to exercise due professional care and competence. In this particular one, there are actual civil proceedings that are in place that may last for some time. And so the recommendation on the part of counsel, given that this matter is being adjudicated in Chancery Court, is to place the matter in litigation monitoring status until, at least until that court issues a ruling, and then determine what, if any, further action is necessary. So those are the recommended items for board consideration relating to the items 9 through 14 in the proposed discipline section of the legal report agenda.
All right. I'll ask one question. Got one question. Number 10. The worded version from yesterday. The paragraph that says respondent states that they were preparing the report. You see that paragraph?
Which paragraph is it? Second. Oh, yeah.
Second.
The beginning of
okay,
second
the
paragraph.
last sentence there says respondent states that after notification by the state, they will follow up with the client to inform them of their error. I don't believe you mean to say that they'll do it after they receive notification from the state. Aren't they going to do that anyway?
Well, and that is just their intention. I don't really know what they'll actually end up
It
doing.
sounds like we're waiting on notification from the state. Is that what you mean to? It says they will inform them after notification from the state.
Yeah, and that is how the respondent's response was formed.
You're quoting them, that's fine.
I am. I'm not. I am using what they have provided to us. Sometimes it is difficult to follow certain.
They probably meant due to the notification from the state, not after.
And I could confirm what the
fine.
response was.
It's fine. I don't think it changes the structure of what you're saying. Oh, man. Good job on those changes from yesterday.
Well, thank you. I could not have done it without you.
Aren't you glad I'm here today? I'm tougher on the phone than I am in person.
All right, Mr. Chairman, thank you. So we have a motion as presented by the committee. Do I have a second?
Second.
All right. Any discussion? Seeing none, I would ask for roll call.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore.
Aye.
Greg Gilbert. Aye. John Griesbeck. Kevin Monroe.
Aye.
Gay Moon.
Aye.
Rob Vance.
Aye.
All right, thank you. Just as an observation, we may want to consider changing our form on legal report summary. Chairman Monroe did a great job of dancing between two sheets of paper so we could get the case numbers in there. And if we could just change under case number, if we could just actually put the physical case number and then add another line that says item number so it corresponds to our item numbers on our sheet. And then the next column will be case numbers. And then that way we could have our summary sheet that would be kind of correspond better with our detail report.
Okay, so you want the legal report to get changed and the. I'm sorry.
No, just the summary report.
Okay, just the one sheeter.
Yeah.
Okay.
And I apologize, but Sherry used to do this, and so we kind of threw it together quickly, but I understand what he's saying on the summary.
And that's it, just as a consideration, that would be helpful, I think,
No.
to the committee
Thank you.
and also to the board. With that being said, then yesterday, the executive committee came together and met. We went through the fiscal year 22 preliminary financial results with the aid of our executive director. We also covered our travel reports. They were presented. And we won't go with everything that we're presenting today as executive committee. We went in detail, so we have public record of that yesterday. So we're going to offer some summary statements here. We actually went through the fiscal year 24 proposed budget, even though we haven't gotten to that point, but we have our budget together as presented yesterday. I would like to note again that our board, our committee brings before the board a statement that we really want to be involved with NASBA, and we want to travel, and it's at our discretion with our budget to build that in. So it is with this vote, it would be a board statement that we agree that we won't travel to attend all the changing things that are happening in our profession, since we've never seen anything like this before. I'll go on record again to say that a lot of boards, 100% of their boards come to these meetings, and we have cut that back to where we do not take everybody, but we rotate around based on those who verbally say that they would like to attend or have the ability to attend. And if you haven't gone, I would encourage everybody on this board to consider that when those times come up to put your name in the pot. And then also with that, we went through our state-specific ethics, and we actually changed our 2023 course outline as presented yesterday by Wendy, that they had gotten together with the author and also the TSCPA. We value that relationship with Tennessee Society of CPAs and appreciate what they do, and we do believe as a committee that there needed to be some changes in that area, and so those changes were presented yesterday. And with that, I bring forth to the board a recommendation from the committee that those two action items, the 24 proposed budget and also the state-specific ethics 2023 course outline be approved. And do I have a second?
Second.
Do I have any discussion on each one of those, or I put them both together to kind of speed things up, but I think that we pretty much vented that yesterday with any discussion we had on each. Seeing none, I'll ask for the roll call.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore.
Aye.
Greg Gilbert.
Aye.
John Griesbeck.
Aye.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Rob Vance.
Aye.
Chairman, could I say something about what you just said and what we voted on?
Yes, sir.
The relationship that we have with TSCPA is first class, and as we travel and talk with other boards across the country, they don't always have that same good relationship that we have. Now, I think it's the majority of them do, but not always. And I'd just like to thank Kara for her great job that she's doing. She had some big shoes to fill, and she's doing a great job doing that. And I just appreciate the relationship that we have, because just like the situation with Pipeline trying to create more enthusiasm in the profession, a lot of the boards that you talk to say that, we're trying the best we can. We're trying to do the best we can to try to get enthusiasm, but we just can't get that society to help us. And so in our case, it's a mutual thing, and we're working together on that. So thank you, Kara, for doing a great job.
And I would like to second that. I think that it goes without saying that yesterday we had a representative from Tennessee Society of CPAs that was present. Today we have Kara Fitzgerald from the Tennessee Society, and we appreciate the relationship we have. There are a lot of boards that do not have that relationship, and that was well put, Larry. So we appreciate that. All right, so now we come to some new business, and we are in need of an investigator, since our investigator has moved up within the state of Tennessee. And I'll let Wendy go through and talk about the person that she's going to present today for consideration to offer a job to.
Thank you, Honor. So what I'm going to do today is just highlight kind of the process we went through in order to solicit applications and interview, and how we got to the recommendation for you today. So we did post the position of investigator as a full-time position within the state and externally at the early part of September. TSCPA did assist us by also sharing that on social media and on their job postings page to help us get the word out. We ultimately received 16 applications. Only 9 of the individuals were CPAs, which has been a requirement for this position. And so those were the 9 individuals that we considered. 5 were selected for an interview, with 1 who ended up declining due to a change in circumstances. So we had 4 interviews, and we scheduled those for Monday, October 10th. Chairman Bonner, myself, and Don Coleman from our HR department sat in on on all 4 interviews. As a result of those interviews, we are recommending an individual by the name of Duke Speed for this position. And I did include his resume in your pre-materials, but I will highlight some items from our interview and from the resume. Duke is an actively licensed CPA in Maryland with an MBA from the University of Tennessee. He has agreed to obtain a reciprocal license in Tennessee should he be formally offered the position. I did check on his license statistics. I checked with Maryland. There have been no issues with the license. He has 22 years of experience with the FBI. 6 of those years was in drug trafficking investigations. And during that time, he was a recipient of an Outstanding Criminal Investigation Award. He spent 2 years as a supervisory agent. In that role, he mentored, coached, and other individuals and optimized processes. He spent 12 years as a special agent in complex financial crimes, payroll fraud, elaborate Ponzi schemes, and money laundering operations, with several high-profile interviews. He developed supportive documentation for prosecution and worked with legal teams to secure convictions. He received a Medal of Excellence Award in 2018. He has experience evaluating complex financial statements, analyzing suspect mergers and acquisitions, and detailed business valuations to identify fraud. His desire is to retire from the FBI, but continue to use his skills in a new position. Mr. Speed is located in Knoxville, Tennessee, so this position would be a mobile or remote position in Knoxville, with having him come to the board meetings as we wish. He's open to do that as well. He provided a few references. I did check those references and some of the comments from those individuals. Both were colleagues or supervisors of his at the FBI. The first individual worked as a supervisor as well as a colleague in white-collar crime with Mr. Speed. He felt that I described the position. He felt he would be a great fit for the position. Some of the strengths were that he brings clarity to investigations. He looks for substance, and he also, while working with this individual, Mr. Speed trained several new agents in the process. The second individual I talked to was also, again, worked in a supervisory role, but also as a colleague role. I believe this is common, it sounded like, within the FBI. He felt the strengths of Mr. Speed were a knowledge of the financial sector. He was very trustworthy and has good judgment. To this individual, he was a right-hand go-to person when needed. So when he was out, Mr. Speed was the person he looked to as his right-hand person. He said one of his strong characters is that he believes every investigation should be treated with importance, no matter how big or small. He also highlighted that he has a track record of giving presentations and has been invited to speak at the national level. And this individual also thought that he would be an excellent candidate for the position, and he would certainly hire him in this role. And I guess I will turn this back over to Chairman Bonner to see if there's anything, since he participated in the interviews, if there's anything that he would like to add. I believe we did talk about compensation, and the recommendation here is with a salary of $100,000 for this position, which you would have noted yesterday is included in the budget.
Okay, thank you, Wendy. I would just like to say that we have 4 great interviews. There were some top candidates in the state that were trying to get this position. Duke Speed kind of was just a little bit better and came across great. And I think you can see from the information just presented that he's a strong candidate as investigator. We did comment about his name, and the first thing he said is that, yes, that is my real name. So I was like, Duke, what a cool name. I do want to reach out to say that Don Coleman did a great job from the HR for Tennessee, that he had a lot of good input, sat back and listened and gave us the opportunity to ask questions during and also after interviews to talk about different areas of concern or questions we may have had after we talked to an individual. And it was much appreciated that the state of Tennessee had him on the call with us. And so I appreciate Wendy for arranging that and having him there. And it was an outstanding day of determining who we thought would be the best person to bring forward. So as chair, we bring forward to you a recommendation for Duke Speed to be that new investigator at a salary of $100,000. And I would ask for any questions that the board may have.
Just have one. So assuming we move forward with this, would our recommendation or our motion be that we hire him subject to the reciprocal license, or does that matter? Does he have to have a reciprocal license in Tennessee to?
I think that's up to you. And so I think that could be part of your recommendation. But the qualifications of the individual are up to you.
I guess maybe I'm just suggesting that maybe we should make that part of the approval, because I think it purposes, if nothing else, to have the reciprocal license in Tennessee as opposed to the investigator being licensed in another state.
Has that always been the case, that the investigator had an active license in Tennessee?
Yes, as far back as I'm aware of, yes. The one thing that I will add that I failed to mention is that we are also recommending a start date of January 3rd, the first day back in the office of the new year. So he'll need to give a 30-day notice to the FBI to transition cases. We also have to get approval through the Department of Human Resources, and so that seemed like a doable date.
So how long does that reciprocal process take?
Hours.
Okay.
We just get a letter of good standing from the home state.
We wouldn't want to bring him in and find out work. So.
Yeah, I shouldn't. I've already checked his status in that state, so should be fine.
Ready for a motion. I'd like to make the motion that we offer of employment.
This is Janet. Can I ask a question before we move?
Yes, go ahead, Janet.
Okay, but did you all get a sense of his communication skills, written and verbal?
We did, and from my perspective, his verbal skills were outstanding. He was you could tell that he had been an investigator with the FBI for years, and the way that he responded to questions, the comments he made, he was very thorough. Even when I made a comment, he inquired as to what I meant by that comment. And so I would think that he would be a great person and probably get a lot of information right up front and be able to judge who he's talking to and what's going on in a case. I think the investigative side is going to be outstanding. It was my perspective, and I'll ask Wendy to chime in there.
I would agree. I had no concerns at all with his ability to communicate, and like Andy said, he was really listening and engaging in the interview and asking follow-up questions and those types of things.
What about the written skills? I don't know if through letters that he might have written or anything else. You got a sense about that?
We have exchanged a few emails, and I have no problem with the communication skills as far as the emails, but nothing any further than that.
Okay, thanks.
Any other questions? Fillmore?
I would make the motion that we make an offer of employment to Mr. Duke Speed as our investigator. Employment to begin January 1st, 2023 at a salary of $100,000. And I'm open to changes on this wording of this, but I would say subject to him obtaining a reciprocal license in the state of Tennessee. Successfully obtaining.
All right, do I have a second with that motion?
Second.
Any discussion?
Was it January 1st or January 3rd?
January the 3rd.
Well, I guess it depends on what is
subject to approval by HR.
Would his job actually begin January 1st? But I don't know what Wendy had in mind. I mean, can you be paid for a holiday before you start working?
Let's just say January 3rd.
Okay.
Okay.
I'll amend my motion to begin January 3rd.
All right. Do I have a second to that amendment?
Second.
All right. Discussion. I would like to follow up to make a comment that when we were meeting with him, Mr. Speed did provide information that he does give talks on white-collar crime. So he does do presentations. So I believe that, to confirm further of his writing ability and skills, I think that he has the, based on the way he presented that, it would seem like that he would have that kind of detail associated with what he brings to the table for us. So you might give Mr. Vance a run for his money in presentations there. I think it's.
We're always looking for good FBI agent stories at our forensic conference, which starts today. And we they're kind of hard to find, but now that we've got one in house, I'm excited.
Well, just why he implied several investigations that he had been in and been a part of, and it seems like a very interesting person and probably has some great stories. With that, I would say, is there any more discussion?
Have a second?
Yes, we have a second. I am on the amended motion, a second too. Seeing that, I'll ask for a roll call.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore. Greg Gilbert.
Aye.
John Griesbeck.
Aye.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Rob Vance.
Aye.
All right, thank you. Do we have any other business that we need to bring forth? Any old business or any new business?
Mr. Chairman, can I make a comment? This is related to the NASPA annual meetings. I just wanted to say that those meetings can be attended virtually for anybody who wanted to or needed to attend that way. Just contacting the folks over at NASPA if that's something that somebody wants to do. I've attended them, I think ever since I've been on the committee and on this board, either in person or virtually, and they are very, very helpful and useful. And if you can't attend in person, virtual is an option.
Weren't they free during COVID, but are not free now, or is that not the case?
They're still free.
Are they still
Yeah,
free?
as far as I know,
Yep.
yeah, they're still free, virtually.
Good information.
Well said, Mrs. Booker. Thank you very much for bringing that up. I would say that if you can attend personally, you get a lot more out of the program because of the fact that we get to meet by region, and some of those are not broadcast live. You just get the speaker information for the main programs. So there's a lot of discussion that goes on between boards as far as in those breakout sessions as we go around and kind of talk. And so we also get the ability to ask the speakers questions after the fact, which I always enjoy and get a lot out of too. But yes, if you cannot attend, please consider going out to the website and signing up for that and getting in on the video. And I believe they also have the videos after the fact too.
Correct.
that you can watch them. And so that's very well said. Thank you for bringing that up. Any other? I would like to just step up and say from a chair's perspective that Mr. Crenshaw, and thank you for your comments related to our council, and I appreciate you stepping out and asking us to pause and coming back with the information, and also for not engaging Mr. Culpepper without his council present. And so we appreciate you, and we're excited to have you with us. As I probably said yesterday, we're kind of tough on council here. However, we appreciate everything you're doing, and if you'll just bear with us, we'll get you to a point where we won't have to ask so many questions.
It's not a problem. I appreciate all of you, and I've really enjoyed my almost 6 months with the board so far, and so I look forward to better English, better grammar on my reports, and I really appreciate all of you being so gracious with me, and Wendy too. She's been a great resource and just a great executive director to have by my side. So I appreciate you all.
Thank you. And Wendy, as always, thank you, and board, thank you for all that you do, and we appreciate everything, your time and your commitment, and what you bring to the state here in these meetings. And with that, I would like to ask for a motion to adjourn.
So move.
Second.
Second. Okay. Thank you very much. We'll see you next quarter.